1.
Presentation 1 by Marcus Rice. Presentation 1. What is the difference between Title VII and Title IX? Does Title IX apply to same-sex harassment? How do these influence schools and students? Questions that must be answered. First, what is Title VII? And what is Title IX? According to the Civil Rights Act of 1964, Title VII states, "It shall be an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." Title VII prohibits discrimination in employment on the basis of race, color, religion, sex, or national origin. In certain instances, differential treatment is allowed for religion, sex, or national origin if it is a bona fide occupational qualification. Sexual harassment is also prohibited under this law, as are all forms of harassment based on membership in a protected class. Title VII. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. It generally applies to employers with 15 or more employees, including federal, state, and local governments. Title VII also applies to private and public colleges and universities, employment agencies, and labor organizations. What does this mean? Employees cannot discriminate in any aspect of employment. It also prohibits retaliation against someone for asserting Title VII rights. Title IX. Title IX of the Education Amendments of 1972 protects people from discrimination based on sex in education programs or activities that receive federal financial assistance. Title IX states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. Title IX prohibits sex discrimination in educational institutions that receive federal funding, which is the vast majority of schools. While Title IX is a very short statute, the Supreme Court decisions and guidance from the U.S. Department of Education have given it a broad scope covering sexual harassment and sexual violence. 9 things to know about Title IX. 1. Title IX is a civil right that prohibits sex discrimination in education. 2. Title IX applies to all students regardless of gender identity. 3. Schools may not retaliate against someone filing a complaint and must keep complaints safe from other retaliatory harassment. 4. Schools should ensure that no student has to share campus spaces, such as dorms, classes, and workspaces, with other abusers. 5. Schools can issue no contact direction to prevent accused students from approaching or interacting with you. 6. Schools must be proactive and ensuring that your campus is free from sex discrimination. 7. Schools cannot discourage you from continuing your education. 8. All schools receiving federal funding, including public K-12 schools and the majority of colleges, are subject to Title IX. 9. Schools must have an established procedures for handling complaints of sexual discrimination, harassment, and violence. Both Title VII, both Title VII of the Civil Rights Act of 1964 and Title IX of the Education Amendments of 1972 provide protection against sex discrimination in the context of tenure. So what is the difference between Title VII and Title IX? Title VII is a federal law that prohibits discrimination in employment on the basis of sex, as well as race, color, national origin, and religion. Title IX is a federal law that prohibits sex discrimination in education, covering all staff and students in any educational institution or program that receives federal funds. Title VII and Title IX are similar, yet different from each other, as seen in this circuit split. Courts have ruled Title VII preempts Title IX. Courts have decided that Title VII guides Title IX claims because it provides case law dictating the prohibition of sex discrimination. Unlike Title IX, which was enacted to prevent federal funding of discriminatory actions pursuant to Congress's spending power, Title VII was enacted with a compensatory scheme in mind. The differences. Individuals employed by educational institutions are covered by terms of Title IX. Many claims have been filed under Title VII, but other times Title IX may be used. Title VII contains an express cause of action, provides for specific compensatory damages. Plaintiffs under Title IX need not exhaust administrative remedies or receive a right to sue letter from an administrative agency. Title IX damages vary from Title VII's. Title IX has no damages cap. Federal agencies may withdraw their funding under Title IX, but this is not the case under Title VII. Title VII was enacted under the spending clause powers. Federal funds may be revoked if there is a violation of Title IX. Does Title IX apply to same-sex harassment? Title IX protects all students from sex-based harassment, regardless of the sex of the parties, including when they are members of the same sex. How do these influence schools and students? Here are a few universities that have had Title IX suits over the last few years. Title IX and K-12 schools. 9 ways Title IX protects high school students. 1. Sports participation. Other sport benefits and opportunities. Sexual harassment and sexual violence. Hazing, bullying and cyberbullying. Other school activities. Pregnant and parenting student athletes. LGBTQ students. And retaliation against reporters of Title IX violations. 2016, women earned about 80% of men. Within higher education, this gender gap persists in salary hiring, promotions, and other aspects of academic employment. Professors can simply attempt to remedy this under Title VII of the Civil Rights Act or Title IX of the Education Amendment, both of which prohibit sex discrimination in higher education. Here's a court case, Doe versus Mercy Catholic Medical Center. Doe sued Mercy in the district court under Title IX for retaliation of quid pro quo harassment and hostile environment. She conceded she never filed a charge under Title VII of the Civil Rights Act. The district court held that Title IX does not apply to Mercy because it is not an educational program. Here's the case continued.